Welcome everyone. My name is Ayushi Jaiswal. I am currently working as an assistant professor, School of Legal Studies in BBD University. This is a series of lectures on the Criminal Procedure Code. And the topic for today is Introduction to Procedural Law. Laws are the set or systems of rules established by the government for the citizens to obey and also to govern their regular behaviors and conduct. They are usually enforced by governmental institutions. The mechanism of the law ensures that all citizens abide by them and that the society can function safely without any obstructions. In India, the laws are made by the Indian Parliament, implemented by the executives, and interpreted and enforced by the judiciary. Laws can be further divided into two broad categories. They form the two major branches of law. One is substantive law and the other is procedural law. Substantive laws are basically the statutory laws passed by the legislature, while procedural laws comprise the rules and processes which any court follows for hearing and determining. Now, what is a substantive law? Substantive law is a statutory law that defines and determines the rights and obligations of the citizens to be protected by law. They define the crime or wrong and also their remedies. They determine the facts that constitute a wrong, that is, the subject matter of litigation in the context of administration of justice. The substantive law defines the remedy and the right, includes all categories of public and private law, and also includes both substantive civil and criminal law. It can be said the substantive law is the statutory law that deals with the relationship between the people and the state. Therefore, substantive law defines the rights and duties of the people. It refers to how facts of each case are handled and how to penalize or ascertain damages in each case. Here are the few examples of substantive law: Law of Contract, Sale of Goods Act, Partnership Act, Indian Succession Act, Hindu Marriage Act, Transfer of Property Act, Specific Relief Act, Indian Trust Act, Indian Penal Code, Domestic Violence Act, the Juvenile Justice Act, the Sexual Harassment of Women at Workplace Act. For example, the Contract Act will define your rights and liabilities which are contained in the agreement which both the parties agreed on. But the procedure, how your contract, when there is a breach of contract, then what procedure will be followed by the court, that is provided by the CPC, procedural law. What do you mean by procedural law? Procedural law is basically the law which outlines the process that courts must follow when adjudicating civil, criminal, or any administrative cases. It deals with the enforcement of law, which is guided and regulated by the practice, procedure, and machinery. Procedural laws act as the machinery for enforcing rights and duties. This law is very important in administration of justice. Procedural law functions as the means by which society implements its substantive goal. Procedural law is very important in the sense that if the rights and liabilities have been given in a particular act, then where is the procedure given? How are you going to claim that right if there is no procedure? For example, various offences have been defined in Indian Penal Code, which is a substantive law. But what is the process by which you are going to get justice delivered? It has been provided in Criminal Procedure Code, which is a procedural law. It tells you about how FIR is to be lodged, how inquiry is to be done, and how finally the trial has to begin, and what are the various processes in between, the kinds of trial, etc. So procedural law is derived from constitutional law, statutes enacted by legislature, law enforcement agencies, promulgating written regulations for their employees, which may not have the force of law, but their violation may result in internal sanction, and the rules and procedural guidelines laid down by the Supreme Court. Comprise the rules by which a court hears and determines what happens in civil, criminal, or administrative proceedings, as well as the methods by which substantive laws are made and administered. The rules are designed to ensure a fair and consistent application of due process and fundamental justice to all cases before any particular court. The validity of the substantive law is tried and tested through the procedures of the procedural law. In the context of procedural laws, the rights may not exhaustively refer to the rights of information, rights of justice, rights to participate, and general civil or political or here are the few examples of procedural law in India: the Code of Civil Procedure, the Code of Criminal Procedure, the Indian Evidence Act, the Limitation Act, the Court Fees Act, the Suits Valuation Act, etc. Procedural law is always subservient to the substantive law. Nothing can be given by a procedural law what is not sought to be given by a substantive law, and nothing can be taken away by the procedural law what is given by substantive law. Here are some key differences between substantive law and procedural law. Number one, the substantive law defines and determines the obligation and rights of people and legal entities, while the procedural law lays down the method of aiding the steps in the procedure for enforcement of law, civil and criminal. When a particular law defines rights or crimes of any status, it is called substantive law. It defines how a crime or tort will be charged and how the evidence and case facts will be presented and handled, while the laws that determine how the rights of the plaintiff will be protected and enforced throughout the course of the case. Procedural laws, it includes procedure, pleading, and evidence. A substantive law also provides for prohibitions administered by court, which behaviors are to be allowed and which are prohibited. Such law providing prohibitions against murder or the sale of narcotics, while procedural laws provide rules to determine how the substantive law are to be administered, enforced, changed, and used in the mediation of disputes, such as filing of charges or presenting evidence. Substantive laws control and govern the rule of law as a whole, while procedural law exclusively deal with the proceedings in the court and the method to start a legal case. Substantive laws are regulated by the acts of parliament and governmental implementations, while the procedural laws are regulated by statutory laws only. In case of substantive law, it has independent powers to decide the fate of each case, while in procedural law it doesn't have any independent power to decide such a fate. In substantive law, it doesn't exclusively deal with proceedings inside a court, while procedural law deals with the happening of. To conclude, we can say both substantive and procedural laws plays an important role in an administration of justice. Substantive laws deal with the rights and obligations of the individual towards one another and towards the state as well, while these laws also deal with the objectives and subject matter of the litigations. On the other hand, procedural laws supervise and direct the proceedings of the litigation of any particular case. The substantive and procedural laws are complementary to each other. One cannot exist without the other. While substantive laws explain the guiding rules and regulations as per law, procedural law describes how the laws are to be enforced. As rightly held by Honorable Supreme Court and confirmed in several other cases, a procedural law is always subservient to the substantive law. Thank you so much.